Federal versus state court systems and jurisdiction. Federal system. The federal courts have a tiered system much like the state court system. Here you see 3 tiers, just as you did in the previous lecture. The federal district courts are at the bottom, and this is where you get, for example, the Northern District of California. There are 94 of these courts across the continental United States and the territories, and there are about 678 judges who are employed in them. Then we have the U.S. appellate courts, where you would appeal federal district court cases, and there are 13 of these courts. We call them circuit courts. So if you've ever heard of the Ninth Circuit Court of Appeals, then that's exactly what we're talking about here. That's number 9 of 13, and this employs 179 judges. And then we have the Supreme Court of the United States. There's only one, and it employs 9 justices. The difference between a judge and a justice is where they work. The justices happen to be up here in this court. We also have a couple of other courts which don't exactly fall into this tiered system but are also federal courts, including the U.S. Court of International Trade. Similarly, we have federal bankruptcy courts. They employ 352 judges across the country, and they operate kind of up there where the appellate level is. And then we have 551 magistrates who assist at the federal district court level. Magistrates are like helper judges. They help with judges' caseloads. They can hear cases themselves even though they don't have full titles of judges. We have similar things in the state courts where we call them commissioners in California, and they have other names in other states as well. We call these courts that you see here the Article III courts, and the judges who work for them Article III judges. They're named this because they come from Article III of the U.S. Constitution. That's the article which talks about the judicial branch. It's actually a very, very short article. If you ever have any time to see, you're sitting on BART, pick up a copy of the Constitution and give it a read through. You'd be surprised at how short it is. So Article III judges, they have some very unique traits, and here are a couple of them that I want you to know about. The first thing is that if you are an Article III judge, you are appointed by the President, whether you're a judge at the U.S. Supreme Court level or you're a judge down at the federal district level. You can only get in by being appointed by the President of the United States. This is why it's so important that vacancies come up when vacancies come up during a particular president's term, because it's that president who's going to be able to seat that new judge. If a judge retires or passes away during the time of the president, then that's the president's chance to put in a new judge there. This is important because of number 2. Judges in Article III courts have lifetime tenure. They don't have to run for office again. They don't have to get appointed a second or third time. Once they're in there for good. Whether until they die or until they resign from their post and go into retirement, they pretty much are there, and you can only get rid of them by number 3, which is removal through the impeachment process. It's a highly procedural process which requires them to be removed only for very specific things and to go through a particular process which allows them to have hearings at the congressional level. It's very difficult to remove an Article III judge. We don't do it very often. In fact, I can't think of any off the top of my head who have been removed. It's a very tedious process to go through, and so we don't really remove them very often. So when you get an Article III judge in there, you got to make sure you have someone that you really respect and that's going to be a good choice, because they're going to be in there for life, and it's difficult to get them replaced. So let's talk about the Supreme Court of the United States. This banner comes from supremecourt.gov. It's the website of the Supreme Court of the United States. My, how times have changed. I highly suggest, if you are surfing through, to go to this website and check it out. It has a lot of very interesting information about the U.S. Supreme Court, including biographies of each of the justices who sit on the court currently and in the past. So let's talk a little bit about these justices. The Chief Justice of the United States is John G. Roberts, Jr. Then there are 8 Associate Justices. Associate Justices is just our name for any justice who is not the Chief Justice of the United States. We have Antonin Scalia, Anthony M. Kennedy, Clarence Thomas, Ruth Bader Ginsburg, Stephen G. Breyer, Samuel A. Alito, Jr., Sonia Sotomayor, and Elena Kagan. To the right of these names, you'll see a picture of the Supreme Court building. This is actually a picture that tells you where to go if you want to take tours. You can enter through the northwest or southwest door, which are on either side of the large columns, and that's where you can enter in to get a glimpse of what the Supreme Court does on a regular basis. And you can see the wings extending out to the right and left where they hold different cases, and they have their court personnel and staff working in there. So let's talk about the justices of the Supreme Court. I just want to tell you a little bit about each one, just to give you an idea of who they are and when they got there. Associate Justice Ruth Bader Ginsburg was born in Brooklyn, New York in 1933. She is nominated by President Clinton, and she took her seat in 1993. Justice Elena Kagan, you may have heard her name before as the former Solicitor General. She was born in New York, New York in 1960, and she was nominated by President Obama in 2010, and that's when she took her seat. Chief Justice John Roberts, we spoke about him briefly as being the Chief Justice of the United States. He is the head of the judicial branch. He is born in Buffalo, New York in 1955. He was President George W. Bush nominee, and he took his seat in 2005. By the way, I would suggest looking them up on their website because their pictures are much better there. These ones are quite fuzzy, at least to me. Anyway, Stephen G. Breyer, Associate Justice, was born in San Francisco, California on August 15, 1938. So we have a local San Francisco justice here, and he was a President Clinton nominee who took his seat in 1994. Associate Justice Samuel Alito Jr. was born in Trenton, New Jersey in 1950. He was also President George W. Bush appointee, and he took his seat in 2006. Associate Justice Sonia Sotomayor was born in the Bronx in New York in 1954. She is also a President Barack Obama nominee, and she took her seat in 2009. Justice Antonin Scalia is an Associate Justice who was born in Trenton, New Jersey in 1936. He was a President Reagan nominee, and he took his seat in 1986. Associate Justice Clarence Thomas was born in the Pinpoint community of Georgia near Savannah in 1948. He is a President Bush nominee, and he took his seat in 1991. And Justice Anthony M. Kennedy is an Associate Justice who was born in Sacramento, California in 1936. We have another local Californian, and he was nominated by President Reagan, and he took his seat in 1988. Article 3, Section 2 is the part of the Constitution where you can read about the federal court's jurisdiction. This means what type of cases the federal court can hear, from down in the district court level all the way up through our esteemed justices that we just heard about. What is jurisdiction? In this case, it's the legal authority of a court to hear and decide a case. In other words, is this in their playing field? Are they able to actually hear this case because it's properly before them? You can think of jurisdiction in a lot of ways. For example, if you have particular police officers who are from a different state, they may not have the jurisdiction to arrest you in California. This means that they don't have any legal authority to do what they need to do to carry out their job. Same thing with jurisdiction in the courts. If they are not in the proper jurisdiction, then they don't have legal authority to do their jobs and hear the case. So what do you need to do, and how can you sue in federal court instead of having to bring your case in front of the state court judges? The first thing you can do is something called diversity jurisdiction. That means both of the parties are from different states, and the amount in controversy, that means the amount that's being disputed over, is over $75,000. For example, you have plaintiff who is suing defendant over a car crash. Plaintiff is from California, and defendant is from Nevada. And the amount of the car, I guess it'd have to be a very expensive car. Maybe I should say something else, but we'll say that the car was worth $76,000. Someone can tell me what type of car would be worth $76,000. I definitely don't have one. But then that would be a case of diversity jurisdiction where you could come together and ask the federal court to hear the case. Now, if you had a similar issue, but you're having plaintiff from California suing defendant from Nevada, and they're suing over a Toyota Corolla, it's not going to be $75,000. The different states' piece alone is not going to be enough for diversity jurisdiction. You also need that amount in controversy, and vice versa. You can have two parties suing for $100,000, but if they're not from different states, then they're not going to be able to use diversity jurisdiction to get themselves into federal court. The second way is under subject matter jurisdiction. So if you can't meet diversity jurisdiction, you may want to go for the subject matter. Does the subject matter arise under the Constitution or a federal law? Does it arise under treaties, or does it involve diplomats or the law of the sea? All of these subject matters are matters that are properly brought before the federal courts because they're federal laws and federal treatises. And the Constitution, of course, is a federal document. State laws, for example, would not have subject matter jurisdiction because the state legislature is the one who enacted those laws. Those should be brought in front of a state court. However, if it is a federal law, a U.S. law, if it is a constitutional law, or if it involves federal parties like diplomats, then this is the type of subject matter which would be brought before the federal courts. Thirdly, any case where the United States is a party. So if the United States is suing somebody, the U.S. versus insert last name here, or if the United States is being sued as a party. Both cases you would be in federal court. So if I can get into the federal court, what do I need to do to get all the way up to the Supreme Court? Well, we talked a little bit about the state court level and having to appeal from one level to another. So I want to talk a little bit about how to get to the Supreme Court because it's a little bit different. We already talked about appellate jurisdiction, and that's how to get to a court by appeals. And we'll talk about that a little bit more. But I also want to introduce to you the idea of original jurisdiction. What original jurisdiction is that the Supreme Court of the United States gets to hear that case first. They don't have to go down to the base federal district court level. They don't have to appeal then to the appeals level and then appeal again to the Supreme Court of the United States. They actually get to start out up in the highest court of the land. And it's only in very special circumstances. So let's take a look at what those are. The court can hear some cases directly, and they're cases that involve specific individuals, ambassadors, public ministers, or consuls. We tend to treat them in a specific way and give them special privileges because of their position. And so cases against them or that involve them are going to be able to start up at the Supreme Court level. Also, original jurisdiction is granted when the state is a party. Believe it or not, sometimes states sue each other, and there are cases that sound much like Virginia versus Kentucky. And in that instance, those cases, because it would be unfair for them to be heard within a specific jurisdiction of a state, they're then brought up to the Supreme Court to start there. Now, if you can't fall under original jurisdiction, because there really is a very thin number of cases that can be brought through original jurisdiction to the Supreme Court, it can also be brought up through appellate jurisdiction. Now remember when we talked about the state court, the Supreme Court of California has the choice of whether or not it wants to hear a particular case. Well, the Supreme Court of the United States has that same privilege as well. They get to decide whether or not to take cases up on appeal. And so say you have a case at the federal district level, it did all of the fact-finding down there, and they appealed up to the appellate circuit court. Then the appellate circuit court took up the case, and the plaintiff was still not happy. So plaintiff wants to appeal to the Supreme Court of the United States. The Supreme Court of the United States can decide whether or not to take up that case. And what plaintiff has to do is they have to appeal to the next level, and then the Supreme Court, if they decide that they want to take up the case, then they are going to issue something called a writ of certiorari. What the writ of certiorari is it's directing the lower court to transmit all of its records for that case up so that they can be heard on appeal. The cases need to involve a federal question of law. They can't just be about state court matters, and 4 justices must agree. Oftentimes, we have cases which involve conflicting rulings, like what we said in the state court level when you have 2 circuit courts, for example, which make different decisions about the same type of issue. The Supreme Court will want to take that and set it straight. Additionally, you may be asking you might have caught the issue that says cases need to involve a federal question of law. And said, well, why is that even necessary? Because we've already been through the different levels of jurisdiction, so why would that even be an issue? And that's because you can submit a petition to get a writ of certiorari from the Supreme Courts of the various states. So say you had a case which went through the state court level, it went through the district court, the appellate court, came up to the California Supreme Court, and the parties are still unhappy. They can actually petition for a writ of certiorari to the Supreme Court of the United States, and the Supreme Court of the United States, which is the final court of everybody, can decide whether or not to take that up. But they'll only take it up if there is some federal question of law involved. It doesn't have to be the only question. There could be state issues in there, but it must have at least one federal question of law in order for the Supreme Court to consider to writ that case and bring it up for consideration. Here is a very blurry picture of the Supreme Court of the United States from the side. And so here's just a wrap-up of what our courts look like. So if you are sitting in Oakland, California today, then your state courts would be as follows. The very first court that you would go into would be the Superior Court of Alameda County. We talked about the 2 different courts in Alameda County and Oakland that serve the Superior Court level. And then, if you're not happy with that, then you would appeal to the California Court of Appeals, District 1. We're in District 1. There should not be a bullet point there. And then, if you're not happy with the California Court of Appeals, then you can appeal to the California Supreme Court. And then, remember, as I said, if you are not happy with the California Supreme Court, you can actually appeal above the purple line and appeal all the way up to the Supreme Court of the United States and petition for a writ of certiorari. Similarly, in the federal system, you can start at the bottom in the Federal District Court for the Northern District of California. And if you don't like what happens there, you can appeal it to the Ninth Circuit Court of Appeals. And if you're still not satisfied, you can appeal up again to the Supreme Court of the United States and petition for a writ of certiorari to be heard there. There are no appeals that go higher than the Supreme Court of the United States, and their decisions are final.